Okay, fine. So we will discuss something from Unit 3 today, appeals, revision and reference part. Okay, this fourth topic we will continue today.
Appeals?
Appeal, revision and reference.
Yes.
This topic. Okay, so yes. Now, when we talk about criminal law, right? Like laws are basically divided in two types, civil and criminal. In case of civil, it's fine because mostly compensation is paid, right? Like if some person has suffered some injury, money will be paid to that person. So as such, there is no problem over there. Or at most, maybe some injunction order would be passed, specific performance of contract. So outcome is like not that severe in case of civil wrongs. But when we talk about criminal justice, it leads to some serious consequences of individual's life, primarily on right to life and personal liberty. If a person is sent to the jail, his right to life and personal liberty is affected, right? That person is not having freedom to go wherever he wants, do whatever he wants. So in such a way, we can say that in terms of criminal justice, the severity is even like higher. What would be the outcome of violating a legislation? That outcome is even more serious. Whatever institutions we see around us built by humans, it will have some or the other problems, right? We cannot make something which is like perfect, no issues or nothing. Everything would have some or the other problem. Same ways, when we talk about courts, there also it's human who are sitting there deciding the case. They might be having problems going on in their own life also. They might also be having some difficulties, right? So when we talk about courts, there also is a possibility that some mistakes might happen. Okay, so resultantly, there should be specific provisions in place so as to scrutinize the decisions given by lower court in order to ensure that justice is served. It's not that some innocent person suffers or something. Like in criminal law, we anyways have one concept which says it's fine even if you are letting 10 or 100 criminals go free, that is fine, but innocent person should not suffer. Why innocent person should not suffer? Because that is like very bad, because outcome is so severe, right? Without doing anything, you should not suffer. That is the main idea which we have in Indian legal system. And because courts are run by humans, there is always a possibility that some mistakes may happen. That's why we need a provision to scrutinize whatever is already decided, to again see, was it properly decided or not. That provision we need. Realizing this aspect, there are certain provisions which have been included in criminal procedure, like appeals, revision, reference, etc. So these help us ensure that even though sometimes some mistake may be there, but we have a chance to correct those mistakes as well. Okay, so appeal is like most commonly used word in English. Yes.
What do you mean by this reference, madam?
Yeah, we come to that also. We have provisions of CrPC. Okay, so reference, nothing but like referring to another body. We say, right, someone is applying for a job where you've been referred by some employee of ours. Same ways, referring it to some other court. Okay, we have a provision also. We will see that. Now, appeal is something which we most commonly use, right? Appeal as in going to the higher court. Now, what is appeal? The word appeal has again not been defined in CrPC, but it can be described as the judicial examination of a decision given by lower court by a higher court. Lower court would pass a decision, maybe parties are not happy with it. So what alternate option parties are having is to go to a higher court and file an appeal. Higher court would see whether lower court decided the matter properly or not. When we talk about CrPC, sections 372 to 394, it is having different provisions relating to appeal. Okay, so there was one case, Satyapal Singh versus State of Madhya Pradesh, wherein Supreme Court held that the father of the deceased has a locus standi to present an appeal to the High Court under Proviso Section 372, as he falls within the definition of victim, to question the correctness of judgment or order of an acquittal of the accused. Take, for example, if the father dies because of some crime scene or because of some incident, okay, and a case was filed wherein accused person got acquitted. Court did not, his guilt was not proved, court acquitted him, that his guilt is not proved, he is released. In such a case, because the son, right, father of the deceased, if he dies, what happens is the son would be someone who is suffering, right? Held that deceased has locus standi. It was held that father of the deceased has a locus standi, or whatever it might be, right? If the son dies, father is someone who is getting affected, right? So father is having locus standi, as in he is having a right to file a case. Okay, even though it was his son who died, it was, in that case also, he would be considered as the victim. Okay, so he will also be having a right to go before the court and question that maybe lower court has not decided the matter properly, and he can file an appeal if he is not happy with the decision wherein trial court acquitted the accused person. Okay, so why this provision is given? Because when a crime takes place, right, anyways, first case would be initiated by state only, right? State versus so and so. So in that case, if court acquits the accused person, their father can go for an appeal, and father can question validity of that decision which was passed by the lower court. Now, in case of appeal, we know if we are not happy with decision of a lower court, we go to the higher court and we file an appeal, wherein higher court looks into the matter and gives a decision. Higher court may change it also. Higher court may even agree that yes, whatever lower court has said, that decision is only proper. It depends on the situation. What is reference under Criminal Procedure Code? So reference is an application made by trial court to the High Court for interpretation or explanation of a matter relating to acts, legislation, regulation, etc. Okay, most of the time what happens is we have so many different legislations available. Okay, we have so many legislations available, so many provisions are there, right? And sometimes it might become complicated, okay, because it would be just one single provision which tries to explain it. It might become complicated for judges also to interpret it, right? When a case is filed in the lower court, take for example, there is a case filed in the district court or maybe in the magistrate court, and district court feels that this is complicated. Okay, this is complicated and we need a proper answer to this certain thing. Okay, we need to understand what the legislation means by this certain provision. In such cases, just in order to avoid that, lower court should not be like, okay, whatever I feel, I would give the decision like that. Lower court should not do it. Okay, if they feel there is a confusion, what they can do is they can refer the matter to a higher court. They can seek help from the higher court, like it happens in our days, normal day-to-day life also, right? If I don't know something, I can take help from another person who is more experienced than me, right? That, can you please help me how to do this certain thing? Same ways, if lower court feels that this certain matter, it is confusing, maybe we need to take opinion of the higher court or something, they can refer it to the higher court that this is what kind of a case has come before us. Can you please help in this? Maybe can you please explain what this certain provision means? Can you please explain how to interpret this provision? Like that, they can refer the matter. Okay, reference can be defined as the terms to consult various information from the trial court, which is to make an application for explanation of legislation, act, regulation pertaining to the case. Reference power is vested with the court. If court feels that we need clarification on this certain point, and only when we get a clarity on this point, we would be able to decide this case. We would be able to give a decision in this case. Okay, in such cases, lower court would refer the matter to the higher court and would tell them that kindly look into this, kindly clarify this certain confusion. Okay, give your opinion. How would you interpret this provision? Give your opinion. Like that, it may be referred. As such, there will be in-depth examination of the laws to ascertain whether there is a misunderstanding, misapplication of the law, or a re-evaluation of the facts of the case with the application of the laws. So higher court would do the necessary things, whatever is needed. They would try to understand that provision in reference to the case which is filed before the lower court. Reference is given under Chapter 30, specifically falls under sections 395 and 396 of CrPC. Section 395 of CrPC, a reference arises when a case is before a trial court, and such a case includes a question relating to validity of any regulation, ordinance, or act, or any provision of the act which is necessary for the determination of criminal case. They need clarity on a certain provision. They need clarity on whether this certain provision is valid or not, binding or not, is it good or not. They need a clarification. Only when they get the clarification, they will be able to decide this case properly. So that is when reference come into importance. As such, the lower court or trial court shall refer to the higher court, to the high court for its cause or opinion. Such opinions or reasons may form the basis of court's decision. In such cases, the accused may be sent to jail or released on bail as there is pending for reward of opinion from the higher court. So the court would take a decision that, okay, fine, what we should do. And based on whatever answer they are getting from the high court, they would decide the matter. Okay. We have section 396 also, which talks about disposal of case according to the decision of high court. There was confusion in lower court. They referred the matter to higher court. Higher court also examined the matter and everything. Now this case has to be disposed, right? That was the main purpose of referring this entire confusion to the high court. So how will this case be disposed? When the question has been so referred, the high court shall pass such order that it thinks fit, and also can send a copy of such order to the lower court, which shall dispose of the case comfortably to the said order. The high court may also direct the cost of such reference which has to be paid. So high court may say that, okay, this is what we have found based on our understanding, examination, or whatever, and based on that particular answer. When high court answers it, high court clarifies a certain thing, based on that, lower court would try to give a decision on that case. Lower court would try to dispose of the case. Okay, is it clear, appeal and reference?
Yes, madam. All reference cases, lower court is taking only clarification to clear ambiguity.
Yes.
So decision will be taken only by the lower court.
Yes, decision lower court will take, but high court will just try to answer it. That maybe this is what it means. Next we have is revision under CrPC. So revision or modification is a rule that is to correct or change a decision which is already made. Decision is already made. Now we want to revise it again. Okay, usually the high court has power to re-examine the case which has been dealt by the lower courts. This power is not like appeal. High court can determine whether to examine a case or not. The purpose of revision is to reassure the legal procedures which were exercised by the lower court is without any errors while delivering the verdict. Revision in High Court falls under revisional jurisdiction, and we have in chapter 30 sections 397 to 402 cases are usually filed under section 397 that deals with provision relating to revision. Revision can be done by high courts. It is mentioned in the code to serve as a check and also to ensure that High Court has power to see that justice is served in accordance with the rules and the law. The amendment ensures that court does not abuse its powers and exceed its jurisdiction as provided by the court. So when there is some kind of error, revision application may be filed in higher court to ensure whether all these rules, regulations, point of law that applies, whether case was decided based on that or not, whether case was proper or not, that thing would be ensured, and based on that high court may say that okay fine, this was proper only. Like how it normally happens, right? We study a certain topic, maybe we are writing some assignment. After writing the assignment, we again revise whether everything is done or not. While answering in examination also, we write everything and then revise the question paper, whether we have answered all the questions or not. That is nothing but seeing again that by mistake, have I missed any of the questions that I know the answer also, but by mistake, maybe I skipped it, right? So I would see it again. Same ways, when a case is decided, it has to be done based on some, like points of law, some rules, regulations need to be followed. Whether all of that was done or not, that thing will be seen by the courts. Okay, now here we have this differences, points of difference between appeal, reference, and revision. This table is very important. You can refer this particular table also when we talk about their differences. Okay, so for these two, reference and revision, it is given in chapter 30 of CrPC. For appeal, it is given in chapter 29 of CrPC. When we talk about sections, it is 372 to 394, 395, 396, 397 to 402. Now, which section deals with it, that is not like a point of difference, but yes, it is some like important point, like which section deals with what, that is important. But as such, which section deals with what, that is not like a ground of difference, because obviously same section would not deal with 2-3 different things, right? But it is just something that we can refer. Now, an appeal is made to the higher court on points of fact and laws. In case of reference, reference is made to the higher court on points of law. Revision is made to both higher court as well as lower court on already adjudicated matters. When we talk about appeals, there sometimes you would see that case would be filed and parties may say that, okay, there are these new, new facts which we have come across. These were not taken into consideration by the lower court, or might be this is what the situation happened, but lower court just, did not entertain the matter. Like there was one appeal recently where I think in Rajasthan, in a school, there was a kid who ended up committing suicide. And then there was one like teacher, okay, this physical training instructor, he was scolding the student one day because of bunking classes. And then the student ended up committing suicide because this situation like repeated for a few times. The student would bunk classes quite often, and then the teacher would scold. And then he said that, okay, like this is enough. He is insulting me in front of everyone. And he ended up committing suicide. And in that, while committing suicide, he wrote a suicide note also where he mentioned that name of that teacher, thank you, and the name of the teacher. And also another piece he wrote like needed justice. Okay, when FIR was also filed against the teacher, and then the teacher filed a case in the High Court, basically, okay, Rajasthan High Court, and High Court simply dismissed the case. He was not happy with that decision, so he filed an appeal before Supreme Court. That was on point of fact also, that this is what has happened. I have not as such abated the suicide. I have not done anything for which the child should end up committing suicide. But if he has done, I don't have any fault in that. Okay, because he was doing something wrong and it was my duty to correct him. I was just performing my duties. In that case, Supreme Court did take into consideration the facts also. Supreme Court said that yes, he is a teacher, that too he is a physical training instructor. He was a member of disciplinary committee also. So definitely he is having a responsibility to correct students if they are bunking classes. As such, it is not something where a child would end up committing suicide. The teacher never expected that to happen. Okay, so as such, he is not liable or responsible. And Supreme Court, what it did is it just said that this FIR that was filed, it should be set aside. It's not valid. How Supreme Court said it? Based on points of fact only, right? So it might happen that points of fact, points of law, whatever is the matter, that would be brought before the court, and court would try to decide the appeal, what should be the result. When we talk about reference, it will be on points of law. I would not ask that, okay, this certain situation happened, so was the person present there or not? I would not ask that kind of a doubt to the higher court. But what I can ask is, this is a certain provision in so-and-so legislation. What does this certain word mean? Is it this? Is it that? Right? Like you said, ambiguity in a legislation or a provision, those things we can refer. It is nothing but point of law. And in case of revision, it is just that we want to revise it just to ensure that whatever decision was taken, whatever matter was adjudicated, it was done in a proper order. There was no violation of the existing provisions or something. Whatever rules, regulations had to be maintained, everything was done properly. That is nothing but revision.
Then in revision, madam, it is written that revision is made to both higher and lower court on the already adjudicated matters. So how it comes, revision is made to lower court?
Lower court, as in sometimes it may happen that there can be, take for example, order. The general rule is that once signature is put in the judgment, it should not be changed. Okay, as in this is like final. They would put the signature, it is final, it should not be changed. Like in Hindi movies, we see also they would just, like break the pen also. Have you seen that? When announcing death penalty, they would just break the pen.
I did not notice.
Did not know. It's like old Hindi movies you would see, because nowadays no one uses that, like ink pen they used to use. And when the death penalty would be like announced, that ink pen would have that thing, right? They would break it, like they would write this, put their signature and then break it. So it's nothing but that once you have written it, once you have put your signature, it is so final that you can't change it. So you break the pen itself. Okay, so it's not like they would break it now because they would use different kind of pen. That's a different matter, but that is the thing. Once you have put your signature, you should not be ideally making any changes. But it may happen that there might be some clerical errors or stuff, right? Some calculation mistakes might be there. Some here and there errors may be there, because the, like it might be typed by someone. In that case, some spelling errors, typing errors happen, or might be there is like a list of amount which has to be paid. They have to calculate these many figures. There is a mistake in calculation. In such cases, what would happen is they can make those corrections also. Okay, in the lower court only, they can make those corrections basically. Like even though the normal rule is that there should not be any changes done after the judgment is finalized, but there can be in these cases. Okay, appeal begins on the determination of the case. The reference occurs while the case is still pending in the court. Revision begins under the final judgment or final order or final decision of the court. So appeal is, case is decided, you are not happy with the decision, that's when you would go for appeal. Same ways in case of revision, once a final judgment is passed, maybe there is some mistake in the judgment, in the order or something, there you would go. But when we talk about reference, it is in relation to a pending case, because there is a difficulty that the judge is facing in understanding a matter, and judge wants answer to that question so that it can decide the matter. So reference will be in relation to a case which is still pending in the court, and the matter is ultimately referred so that they can decide on this particular case. Okay, an appeal or petition is to be filed against the decision passed by lower court. Reference is to consult High Court on insolvency or invalid law, act, regulation, ordinance related to the case. Some confusion related to the case, some legal confusion related to the case, matter would be referred. Revision is to change or amend any, say this one, grammatical, clerical, arithmetic error by a trial court or high court. Some mistake has happened, it would be referred. In some cases, an appeal can be filed with leave of court by an aggrieved person or accused. Reference is made by trial court to the high court. Revision can be initiated by trial court suo motu or by the high court. So in case of appeal, mostly it happens that the legislation itself would specify that if you are not happy with this decision, you have 90 days. Within 90 days, you can file an appeal to the higher court. If you have filed the case before high court may certify that yes, if parties want, they can go to the Supreme Court within this time. Like that it happens. But sometimes it may happen that High Court has not certified your matter. As in High Court don't think that this matter is important enough that you file an appeal before Supreme Court. But for you, it is very important. There what happens, you can take leave, with leave of the court, as in with permission of the court, you can file an appeal. Even though the lower court, the high court has not maybe certified the matter, you can seek leave from the Supreme Court. You can seek permission from Supreme Court. And if Supreme Court feels that, yes, maybe this matter is important enough, Supreme Court can entertain the application also. Okay, reference is made by the trial court to the high court. Obviously, when there is a confusion, it would be made. Revision can be initiated by the trial court suo motu or the high court. So if there is a mistake or anything, suo motu, it can be initiated on its own. Suo motu, it can be initiated, or by the high court also it can be done. Okay, so this table you can refer for these differences. There is one case, Chandrappa versus State of Karnataka. The appellate court laid down some guidelines relating to appeals against acquittal. When a person is acquitted, his guilt is not proved. And in such case, an appeal is filed. There are certain principles which are to be followed. Where the fact of the case is clearly wrong and warrants a miscarriage of justice. In this instance, an acquittal can be appealed. When a person was acquitted, his guilt was not proved, but fact of the case is clearly wrong. Fact, there are some mistakes in fact of the case. Maybe some parts were not even brought in notice of the court or something. In such cases, appeal can be preferred. In an instance where the trial court failed to make a clear distinction between an indisputable conclusion from the facts of the case, what decision court has given, that decision itself is questionable. That decision is not like, like complete. You still, when you read the decision, there itself like doubts arise. In such cases also appeal may be preferred. Okay, so when can appeal be preferred? How it would happen? Sometimes, yes, High Court may feel like this is not something where appeal should be filed, but still Supreme Court accepts that no, this matter is having importance, we would decide it. Okay, like if you remember from Kerala, there was this case also, right? National anthem case.
Emmanuel, Professor Emmanuel.
Sorry?
Professor Emmanuel.
Yes,
And his
Professor
3
Emmanuel.
children. Yeah.
Yes, Professor Emmanuel, right? In that case, when Kerala High Court decided the case, Kerala High Court was like, no, this the national anthem is not as such having anything. Why are they not singing the national anthem? Right? So Kerala High Court did not give a decision in favor of the father. Kerala High Court did not even certify that you can file an appeal before Supreme Court. But the father still filed an appeal by way of special leave petition, as in, yes, it took permission from the Supreme Court to file it because the father felt that, yes, this matter is very important, and it in fact became like such a landmark judgment also, right? Talking about freedom of religion.
Right to silence was mentioned in that case, is it, madam?
Not like right to silence as such, it is right to freedom of religion. That, okay, fine, these 3 kids are keeping silent, they are not disturbing others in singing the national anthem. So if you are standing silently without disrespecting the national anthem or without disturbing anyone who is singing the national anthem, that in itself is not like disrespecting national anthem. You have, yeah, you can say related to right to silence, but it was more like right to religion. If your religious like beliefs are being affected, you can stand silently also without disturbing others while they are singing the national anthem. So like that it was. So very landmark case for Constitution of India. Okay, so appeal, revision, and reference we have done.